Hi everybody, welcome to Griff's Notes for today, January 5th of 2022. My name is Griffin Bridgers, and it's my pleasure to bring updates from around the country on trusts and estates and what's going on in the world of case law, tax rulings, and even technology. So before we jump into today's presentation, I want to remind you again that this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only, and that this video cannot be relied upon to assess the health of your own estate plan. So today's hot topic will be pay on death or transfer on death designations, POD or TOD designations. I've talked about this some in the past, but what a lot of people don't realize is that any sort of beneficiary designation to an individual will override your estate plan. The only way to make beneficiary designations consistent with your estate plan is to name your estate or your revocable trust or even a testamentary trust as the beneficiary of different accounts. Now, there are certain accounts that are protected, like life insurance and retirement plans. Typically, claims of creditors of the estate can't be paid out of those types of assets, but creditor claims can be paid out of all other assets. However, at the same time, estate tax claims can be paid even against life insurance and retirement accounts. So what we're going to dive into today, and as a supplement to this, there's a Substack article linked in the video notes below if you want to read up more on it. But today we're going to look at the fact that financial institutions which pay out pursuant to a beneficiary designation are protected even if those funds are potentially wrongfully paid out, or if somebody else might have a claim against those funds. We're going to find out that a financial institution really has no duty to dig into the circumstances behind a beneficiary designation and is free to pay out those funds without liability and with immunity unless a written objection is received well in advance of the payment of those funds. We're going to dive into a case that explored this in the context of community property as well. And as I mentioned, if you want to read more about the case or the statute, visit griffinbridgers.substack.com, linked in the video notes below. So to preface, here's an email I got a while back. So this is an email from Fidelity, and look, it just comes out of the gate and says, your account is missing beneficiaries. And it's prompting me to add beneficiaries to brokerage accounts so that that account can pass directly onto that beneficiary. But this is a bad idea. Why? Well, what if the beneficiary I name is ultimately going to receive more or less than they might have under my estate plan by virtue of this beneficiary designation? And what if, too, this beneficiary becomes subject to claims of my creditors by virtue of this payout? Because one thing people often misconstrue is the fact that, yes, if you are an heir or beneficiary, your status as such does not obligate you to pay a decedent's unpaid debts or claims of creditors. However, that immunity goes away with respect to any assets you actually receive from the decedent or the estate that are not otherwise protected from creditor claims. And that would include a brokerage account like here. So any beneficiary I name could become subject to claims of my creditors to the extent of the funds they receive from Fidelity or another financial institution. And the financial institution is encouraged to do this and is incentivized to do so because this allows them to escape liability and clear the account off their books. They don't want to deal with the estate dispute. They don't want the funds to be tied up. They just want to get done. And they don't care whether the funds actually follow the estate plan. They just want to get things done and not deal with a personal representative and not deal with the estate administration side of things. So, that being said, there was a recent Texas case from the federal district court in the Southern District of Texas dealing with this exact same issue with a very popular asset custodian, Vanguard. And what happened here is that a widow had previously been named as a beneficiary under some annuities and a brokerage account, but 2 weeks prior to death, her deceased husband and changed those annuity and brokerage beneficiary designations to send the annuities solely to some relatives in France, and to send the brokerage account one half to those relatives and the other half to the widow. The catch here is Texas is a community property state. The couple had lived there since 1987 as a married couple. So 35 years of being in a community property state means that it's highly likely that these funds could have been community property, and most likely were. So what happened? Well, the spouse objected here. The widow objected and said, hey, you can't pay out these funds. These are community property. They should have gone to me. So she sued Vanguard to try to get those funds back. But guess what? She sued the wrong party. And she couldn't work her way out of this because a financial institution, ultimately under the probate code, and in Texas the estates and trust code, has statutory immunity when paying out funds according to a beneficiary designation, so long as two conditions are met. One, the financial institution has to have received proof of death of the account holder, and two, the financial institution has to have not received any written objection from an interested party to the payment of those funds. And even worse, the financial institution has no duty to investigate any dispute, claim, or circumstance which could affect the payment of funds in accordance with that beneficiary designation. So, for example, if the beneficiary was disabled and the payment of funds could affect their government benefit eligibility, well, tough luck. The financial institution has no duty to dig into that and make sure that they're going to hold back those funds or avoid such an issue. Same thing here. The financial institution had no duty to the spouse to investigate whether the funds were community property. So even though the spouse argued that, hey, you should have known since we've lived in Texas for so long, and since you knew we were married, the Vanguard said, hey, we have no relationship with you. We don't know who you are. We don't know if you're married. We have no duty to dig into the community property status of accounts. And the court agreed here. So Vanguard filed a motion to dismiss. It was dismissed with prejudice, and the court said, tough luck, widow. You have to go deal with the beneficiaries directly to raise this community property claim and get the funds back. The beneficiaries are in France, so it's going to be very difficult to do that internationally as well. So my big note and takeaway here is that as early as possible, any affected party, whether it's the personal representative or in the case of community property, the spouse, should send written objection telling the financial institution not to pay funds out to the individual beneficiaries immediately, at least without first checking with that affected party, whether it's the personal representative or the spouse. Because guess what? The personal representative has a duty to marshal all assets, even if they're not paid out to recipients under the probate process. Those funds could still be subject to claims of creditors, and the personal representative has a duty not just to beneficiaries but to creditors to make sure they're paid. Otherwise, the personal representative is now going to have to go after the individual beneficiaries and say, hey, guess what? You owe the estate money. The individual beneficiary is going to thumb their nose. It's going to be a whole big issue, and it's a whole other fight and claim process that the personal representative now has to go through, potentially with multiple beneficiaries, to claw back assets to pay taxes and creditor claims. As always, if you have questions or topic suggestions, or if you want to submit a case or ruling or other article for review, you can email me at griffin.bridgers@gmail.com, but please note I cannot give tax or legal advice in response to your questions, and that this video is not an attorney solicitation. But thank you again for listening to this episode of Griff's Notes. I look forward to seeing you in my future content.